So thank you for joining us today. We appreciate you taking the time to listen to our presentation and come here to learn more about the different processes for going through divorce and getting through the legal courts, legal process, and coming to hopefully to an agreement or a resolution. One of the most common questions that we're asked by new or potential new clients is how can I get from A to B? How can I get from married to divorce? And a lot of that often depends on their situation, their circumstances, the personalities, the assets that they have, their children, and it's all such different circumstances for people that there's a lot of different types of processes that we can use. And we really try and help potential clients or new clients to get through that system in the best way possible in their circumstances. So we try to guide them based upon the personalities and the situation and what may happen to them and what their goals are at the end of their divorce. Some of these processes will seem like they overlap to some degree. For example, mediation and litigation can often overlap. And we also have the collaborative approach, which is a little bit different, but takes elements from both mediation and collaborative approach. But those are the main three categories that we're going to talk about today: mediation, litigation, and the collaborative process. Just a little bit of background. I want to introduce Rick and I. My name's Teresa Reade, and my husband is here with me today, Richard Reade. Rick and I have been practicing attorneys for over 23 years. We met in law school and graduated together from Pepperdine Law. We both have a history of civil litigation prior to focusing on divorce and family law. We both practiced in both personal injury and some other types of litigation practice, which provided us with the foundation for the court system, the discovery system, and just generally how to guide our clients through the litigation process. It also gave us a good foundation for resolution of cases and understanding what the court process brings to clients and brings the difficulties and the benefits of the litigation process, helps us to guide our clients in all aspects of divorce. In our third year of law school, we both ended up working for a really wonderful attorney. She was a huge personality from New York, and it was a great experience for both of us. And she mentored us both in the family law arena and really taught us that the most important thing that we can do is to listen to our clients and fight for our clients and what they want. Obviously, that's not a blind fight for your clients. You have to lead them and guide them through the process. But it was a really eye-opening and great experience for both of us to be mentored by this attorney. And that background is what led us to start Reade Law Firm and led the focus on divorce and family law. So Reade Law Firm was started about 15 years ago. We focus solely on divorce and family law, which includes not only divorce and paternity, but also enforcement and modification of orders, custody investigations, and parent coordinator services. I am a little biased, but I think we have a great team who really loves what they do and loves working with our clients, and we work well together. Of course, if you want more information, we have our bios and our firm history on our website. I'm not going to talk about that all now. We want to get more into the substance of the webinar. So the webinar today will provide an understanding of the different divorce processes, the key differences between the process, pros and cons of each process, as well as provide some scenarios in which each process might work best in various situations. You should have received a flyer. We're going to go a little out of order from that flyer, but we'll cover the same information. We reserve time at the end for questions and would be more than happy to answer any questions or any discussion or comments that you may have. You notice we're also recording this webinar in the event that you would like to review the material. If you have any people that you know, maybe clients that you work with that would like more information, we will have that ready to send out in the near future. And we'd be happy to send that out to anybody who would like to review the information. So we're going to start the webinar by talking about the mediation process, and I'll turn that portion of it over to Rick.
Thank you, Teresa. Thanks everybody for joining us today. As Teresa mentioned, we've been litigators for a long time, and something that drove home to me during that process, relatively late in the game, was that sometimes people just need a place to talk. And it's remarkable what happens when you put people in a room who otherwise, when they're speaking through attorneys or other representatives, once you actually get them in a room together, the clouds part. It's just amazing what can happen when people communicate directly with each other. And so that's what mediation is about. It's about giving people a place to talk, a safe place to talk. It's voluntary. You don't have to go through mediation. There's no pressure to go into mediation. It's confidential. There are certain requirements to make sure confidentiality attaches in certain circumstances, but for the most part, it is confidential so that you can be open and honest with one another. Um, and the idea being that you cannot later on, if it does fall apart, and sometimes mediations do fail, that if you go to litigation, you can't say to the judge, well, he said or she said in mediation that, that she would do this or give this up or have this parenting plan. Nothing like that can occur. And not only that, the mediator himself or herself is also bound by that confidentiality. So even if it does go to litigation, you can't call the mediator in as a witness to say, oh, this happened during the mediation. There's a confidentiality provision, and it's actually stronger than the attorney-client privilege because parties can waive the attorney-client privilege, but the confidentiality provision, and under Massachusetts law anyway, also provides the mediator with the right to refuse to waive that privilege or confidentiality. So it's very strong and it's sacred to assure the people have a safe place to talk, express their thoughts freely and voluntarily without fear of having it held against them later on. And the hope being that if you can be honest with each other and with yourselves, the goals that each person carries can be met. And maybe after those honest discussions, people can realize, hey, we're really arguing about the same thing. We're just looking at it from the different sides of the lens, so to speak. So that's kind of the theory behind mediation, or at least my philosophy behind mediation, and why I really enjoy it and really I wouldn't say push for it, but emphasize it as a possible means as a process to get from point A to point B, as Teresa said earlier. Go ahead, next slide. So how does the mediator work? Again, this varies from mediator to mediator. Mediation is one of those things where you can't go and watch another mediator, as they are confidential. There are a lot of ongoing classes and trainings that go on where they're what's called fish bowls, where you can see experienced mediators, such as I think some are here on this who are attending this today, demonstrate real life circumstances that maybe they've had in the past. But otherwise, people kind of are learning on their own. Mediators have their own style. They develop their own style after doing this for so many years. And my style is more of a facilitator. You can have some mediators who just want to observe the conversation and play a small part in the process, and will only intervene if it starts to get nasty, if communications. For what I do is very rarely, well, if people are screaming at each other and getting hot, as long as I feel the conversation is productive, meaning that they're not just throwing insults at each other, I will usually not interfere. I'll let that play out and see what happens. Sometimes people just need, like I said, a place to talk. Sometimes talking includes yelling. Sometimes people in our office have commented about what happens behind the closed door. They can hear the yelling and the screaming going on. I come out thinking, oh, that was great. That actually was very productive. So different styles. But then there are other mediators who will be directly involved. Other mediators will actually drive the conversation and steer the parties to certain topics and have a more commanding role in the mediation process. So I always encourage people who come in and discuss mediation with me as a potential mediator, meet with other mediators, talk to other people to make sure that there's a good fit as far as the approach goes. Because a personality become intimately involved in these people's lives, it's important that you're comfortable with whoever is sitting in that chair and driving the conversation or just directing it or facilitating it, as I said. So how is an attorney involved in mediation? The mediator himself does not have to be an attorney. A mediator can be anybody who is qualified, as I mentioned before. But if it is an attorney, they can be the neutral mediator. Only an attorney can draft the pleadings and the separation agreement. Sometimes if the mediator is not an attorney, they can prepare what's called an MOU or a memorandum of understanding, who they pass along to an attorney to draft the pleadings. But typically, sometimes they can attend and advocate for one party during a mediation session. My approach to that, again, this is my philosophy, is that attorneys are not welcome in the mediation session. As I said before, my philosophy is that the mediation is something that provides people with a place to talk. And if they sometimes bring in someone who is a professional, like an attorney, they will often defer to them to speak for them. And I don't think that's as productive as the people talking to each other and with each other and having a conversation instead of having someone else speak on their behalf. But that is a possibility, and it does happen. If there's a significant power imbalance between the two parties, for example, sometimes it's helpful, if only for one session, to have an attorney come in and help out on a legal issue. For example, if there's a complex legal issue, that may be another circumstance where that's appropriate. Next slide. So this is a summary of what I've discussed. It's important that the marital issues that are discussed cover the issues that the judge is going to require be discussed and covered in the separation agreement. Everything from child support, child custody, division of property and liabilities, that type of thing everything needs to be discussed. Otherwise, the separation agreement will be rejected. I've had many people come in for mediation having already trying to submit something to the court to be flat out rejected. One judge wrote on one of them that it was rejected in all respects. And just to make it very clear that the parties had not even come close to satisfying the significant requirements that are imposed not only by state law but also federal law when it comes to the issues that need to be addressed in a divorce. It is less expensive than the other options that we're going to discuss today because you're sharing the cost of one person, a mediator, although it is possible to bring in other professionals for certain instances. As I said before, sometimes you could bring in attorneys to cover legal issues that are specific to the case, or if they're complex financial questions, a financial person could be brought in, or if, for example, there's experts on special needs for children, those types of people can be referred to as well. But in the end of it, the mediator is just a neutral person. They cannot advocate for either party. Sometimes what I'll insist on people to do is to, at the end, or at least during the process, but at the very end, at least when there's a separation agreement, to have someone review it for them as an advocate for them to make sure that they're not giving up too much. Because as a mediator, I cannot say, you might want to think about this, or you're giving up a little bit too much, or this might be a little bit unfair, unless it's blatantly unfair and it's something that the judge may not review as being fair and reasonable under the circumstances, as they will say. For the most part, I will not intervene on behalf of a party, because that would destroy my neutrality. And that I think covers what I was going to say today on mediation. Litigation process is initiated by a complaint. You file the complaint with the court, and what happens is a summons is issued, and it's an adversarial process. You'll see on the complaint itself, it's A versus B, and in some states it's petitioner and respondent, but here in Massachusetts it's like a complaint, like a civil litigation complaint. Your adversaries. It's a process that is governed by special rules of procedure, and if violation of those rules can result in penalties such as attorney's fees and sanctions, or loss of certain rights. Then after the complaint is filed, service of process is required to make sure that the other side is brought into the jurisdiction of the court, and that's by virtue of service of the summons. And then after that part of it, you enter the discovery phase. Are you back, Teresa?
Yeah, thanks.
Okay.
So in a divorce, there's a certain aspect of discovery that's mandatory. There's a list of documents that have to be exchanged in any divorce proceeding. And then in addition to that, there's a lot of options on what you can do. You can ask for documents, questions, admissions, experts, appraisals, the list kind of goes on. So it's a very vague part of the divorce process and can cost a lot of money at times and can take a lot of time. But for many cases, it's really necessary that we get all the information that we need. Then the next phase, it's not necessarily the next phase, but it's the settlement conferences. Um, Generally, we'll have settlement conferences after we gather all the information, which is a logical choice. You need to have all the information to have a reasonable discussion. But it doesn't have to be there. We can have settlement conferences before we file. We can have them right after service. We can have them after the trial in some circumstances if the parties decide they didn't like how that trial went and they want to have a negotiation. But generally, they happen after the discovery phase. This is where litigation and mediation often overlap. We often go to mediation in a contested divorce case, whether it's the four parties sitting down, the two attorneys and the two parties, or it's meeting with another attorney, or even sometimes a retired judge to help us reach a resolution. And if none of that works, then you're looking at a trial date. Every litigated case has to end in a trial or a settlement. You can't settle, you're going to get a trial date. And what that means is presentation of evidence, whether it's witnesses, documents, to the judge who's going to make a final decision. The problem with trials is that there is a limit on what evidence can be presented. We're limited by the rules of evidence. And what people think they're going to tell the judge is often about half of what they actually get to tell the judge. There's a lot of witnesses that can't come in for certain reasons. There's documents that can't be seen for certain reasons. So the judge doesn't get what parties believe is the full story. They get what they're allowed to get. Trials typically last 1 to 3 days. They can last longer. They can last shorter, of course. But most of my trials have ever last 1 to 2 days. There's complex issues, experts, then that's going to put the trial a lot longer. After the evidence is closed, the parties wait for a judgment. Depending on the workload of the judge, this can take anywhere from 1 to 6 months. We've waited as long as 18 months for a judgment to come in. Again, it's a lot of misconception that people believe they're going to find out that day. That's probably the most common question I'm asked by clients when we're facing a trial. So, is the judge going to tell me that day what they're going to do? No. They have to review everything, take time, write up an agreement. In large part, the judgment that is issued when it is done is a final decision. There's some exceptions to that. There's appeals and post-judgment motions, but for most cases, that's the final judgment. It lays out all of the issues, that resolves all the issues that the parties brought to the court. You have to bring them to the court in order to get a resolution. So that's the overview of what the litigation process looks like. Things to consider in litigation. And these are, can be good, can be bad, can be pros, can be cons. They're often highly contested issues. So when there's highly contested custody issues or property division issues, those most likely will need to be litigated. Those aren't really amenable to going to a mediation. As Rick said, we need open communication and kind of a agreement to have a mediation and come and to build their own resolution. When you have people who are highly contested, that's not an option, and that's where litigation can be very helpful. When there's a power imbalance, for example, if there is one person who is dominant in the relationship, if there's a history of physical violence or even emotional abuse, financial manipulation that puts one party at a disadvantage, then litigation might be the only option for them. I discussed discovery prior. So when you're going to a mediation or even collaborative, there has to be somewhat of a agreement, maybe not formal, but some agreement that you're going to exchange the information that you need. Otherwise, it's not a useful process. When you have a party who's not forthcoming with information, then you need to go into the litigation arena where you can file formal discovery, depositions, subpoenas to go get the information that you need. Legal precedent is a consideration. If there's a very novel issue in a case, then you could create legal precedent, meaning rules that are going to apply to other cases in the future. That's really rare. And what's more common is that you're going to create precedent in your own case. So, for example, if you have a judge who decides a parenting plan, that's going to be the jumping point in the future. Or if the judge makes determinations about one person's conduct, maybe property or asset division based upon what's happened in the past, that's going to set the stage for any future issues that arise between the parties post-divorce. And finally, there's remedies available in litigation that you cannot have in mediation. Rick touched upon that. For example, contempts, which is the enforcement of existing court orders, can only happen through a court. So you have to obtain the orders from the court, as we discussed in the past, and then you can enforce them through the court. And if you have somebody who's being difficult, doesn't like to follow the rules, then this is a case that has to be in the litigation arena. And then some drawback to litigation, and these are always going to be issues to be considered when people are just thinking about filing for divorce. One, of course, is the high cost. Litigation can be expensive with attorney's fees, expert fees if you need those, appraisals, and people don't always have a control of what those litigation costs are going to be. If you have an opposing party who's running into court on motions repeatedly, there's some stuff we can do, but really there's nothing we can do. We have to appear in court to defend those motions. Sometimes the court days are really long. Those are just not things that are in our control. It can be a lengthy process, like I said before. Ideally, divorces should be completed within 12 to 18 months, but the courts are still backed up. Hearings are often delayed. There might be delays with certain complex issues with assets. If the parties have issues with their children, sometimes they have a hard time adjusting to the divorce, or there's a what we call resist refuse dynamic, meaning the kids are resisting one parent for real or perceived reasons. We really have to take some time with those cases and make sure that they're getting the treatment that they need, whether it's therapy for the kids, family therapy, and that really delays the process because we don't want to make any final decisions until the children are at a point of stabilization and we know what's in their best interest. There can definitely be an emotional toll. You're living your life of uncertainty throughout the divorce process, not knowing maybe what's going on with the children, maybe what's going on with the house or a business. And you're kind of at the mercy of the other party and sometimes at the court to make these determinations for you. And it might take some time to get a final result. The last one is lack of privacy. It's really surprising to a lot of people to go to court for the first time, walk into a courtroom and see 70 to 100 other people sitting in their courtroom with them, waiting for their own matters to be heard. I've had clients ask me, well, are all these people going to leave? Well, in my case, it's called. And no, you're in open court, meaning whoever's in the courtroom that day is going to be listening to your matter. If your spouse wants to bring their entourage of people, they can do that. It's an open court. It's a public hearing. They can bring, their new girlfriend, their mother, their best friend, whoever they want to bring. What's also surprising to a lot of people is the court files are not private. So I can go down and get anybody's court file right now with some limitation to that. But what people write, people go down and write these motions, laying out all of their family drama, all of their history, issues with their children, and that's public record. They can see it. Anybody can pull the file and read it. Their children can read it at some point when they can go to the courthouse and get those documents. So, people have to be really cognizant that there's really no privacy concern. So Those are definite drawbacks to be considered when filing for litigation. And so now we're going to talk about collaborative, which is kind of its whole separate beast, really. Kind of the same and kind of different, and it's a different world. We're going to describe that and how that works.
Yeah, a lot of people think collaborative is mediation. Oh yeah, I like to be collaborative. I can work collaboratively with the other person, but it's actually a very specific form of alternate dispute resolution that's been around a long time. A lot of people have never heard of it, but it has been around a long time. It started back in the 1980s. An attorney by the name of Stu Webb kind of reached the same point a lot of attorneys reach when they determine that, you know what, there's got to be a better way than litigation. So he started this idea that maybe there is a better way, and he started it, and it's turned into the collaborative process, which is like mediation. There's some overlap between mediation and litigation. It provides a little bit of the best of both worlds, I might say. The only drawback between this and mediation that is afforded to litigants is that there are no rules of discovery. There is no power of subpoena. So there is a lot of trust involved in both collaborative and mediation, but there's more of a support system in place for collaborative, but it is confidential, and the goal is to reach an agreement without going to court. And there is an agreement that all of the people involved, and I'll discuss that in a second, who are involved, but everyone involved has to sign an agreement from the very beginning that they will not go to court, they will not file a lawsuit, and if they do, everyone involved in the collaborative process is prohibited from being involved in any subsequent litigation. So there is an incentive to be committed to the process and to see it through, because there are hard times. It's not easy. Divorce is a hard thing to do. And people sometimes need to understand that as much as we try to describe these processes one way or the other as being something in a positive way, divorce still is a death. It's a loss, and it's hard for people to get through it without being emotional and going through some hard times. But I will try not to oversell collaborative during this, but I do believe it is the best of both worlds as far as litigation and mediation. And so move on to the next slide, please. So yeah, it's not only been around a long time, but it's in a lot of places. You'll see the map here. Collaborative is practiced in all of these countries. It's on every continent except Antarctica. So the penguins down there have to find their own way to do things. But as far as international appeal, it's a very strong practice in Europe. I recently attended a international conference in Toronto, and I met some attorneys from New Zealand, which I think is way down there in the far right corner. So it was really interesting to talk to people who employ this as part of their practice for divorce, but not only for divorce. I should add that it's also used for business dissolutions as well, because I mean, it's kind of similar as a divorce. You're dissolving assets. You're dividing up a partnership or a group or a family, really, and collaborative is a way to do that. So similar to mediation, it is a way to maintain privacy. There are no court hearings. You're not going to court. The parties can control the pace of the process. How long it takes, as I say, for mediation as well as collaboration, and I'll probably say that a lot because there's a lot of overlap, is how long does it take? Well, it really depends on you. It depends on the parties. It depends on how well they're able to work together and put aside their differences and work for the betterment of themselves and for their children. As far as the costs are concerned, it is more expensive than mediation. It's comparable to litigation. I looked at a couple of recent cases that I handled through completion, and we looked at the team and I'll describe the team in a minute, looked at the costs or the fees that were generated, and it was less than what it would have cost for a similar result through litigation. My belief is that it's, as it says here, the focused resources to create the best outcomes. It's money better spent. You're not paying for an attorney to sit in court. You're not paying an attorney to fight it out with the other side, send out letters and discovery requests. Every dollar you spend is focused on that end goal, which is a separation agreement that is fair, that is reasonable, and will be found to be such by a court and a divorce is reached that is for the betterment of everyone, and in my view, better for the children involved. So what are the roles of lawyers? I talked about lawyers' roles in mediation. Teresa touched on their roles as advocates in litigation. It's different in collaborative. The attorneys in collaborative, all of the team members in collaborative need to be collaboratively trained. It is a paradigm shift, as they call it, in the approach and how to handle these cases. You're not fighting for anything anymore. It's a team effort to try to reach what is best for this family. And as lawyers, we still have the obligation, we still have a duty to our clients to advise them of their legal rights, and let them know what the options are in front of them. Not make decisions for them, but just let them know what options are available so that they can make the best possible decision. But to do so in a respectful way, and not to be disrespectful of the other side. And as that, oftentimes litigators tend to lose sight of that. The attorneys will take turns. I usually share the drafting responsibility with the other attorney. Whether one side will draft the separation agreement while the other attorney will draft the other legal documents. There are several documents that need to be filed with any joint petition is what's filed with the separation agreement. The financial statements that are filed, all of those things can be prepared by the attorneys. And just to make sure that, again, the decision making is still with the clients, but again, it's the attorney's job to make sure that the decisions that are made and the terms that are agreed upon are something that the judge will approve as being compliant with what is deemed to be fair and reasonable under their specific circumstances. Next slide, please. So the team members can include, as I said, the attorneys, and then there's also a mental health professional. There are, as I said, I went to a conference recently. There are some collaborative models that do not include a mental health professional. I can't imagine not working with one. Typically, it's someone who has experience in therapy, counseling, social work. They are the process facilitator. They, I wouldn't say run the show, but they administer it. They help coordinate the meetings. They lead the meetings. They help direct conversation. They are trained as far as dealing with the emotional aspect of what's happening to this couple and the family. Oftentimes they will meet separately with the parties. They're not their therapist, and nothing they share with the coach or the mental health professional is confidential as far as the team is concerned. When I say private and confidentiality, the confidentiality and privacy that attaches in a mediation aspect, it applies to in a collaborative aspect as far as it affects the entire team. The team is free to talk to each other. There are no secrets between us. It's important that we have an open and honest communication so that we can make sure that we are fully aware of what's going on and have all the information necessary to properly help these people. And oftentimes what they will do as well is focus on the children. They will have they're a terrific help as far as handling the children's needs and helping formulate a parenting plan that sometimes parents have a really hard time separating what they want and what is best for the children. And I really think that the mental health professional or the therapist or the coach is crucial to helping them separate those two combating elements. And that refocus and shift in thinking can often be the difference in a settlement. And then we also have other team members who can also be a financial professional. I find them to be also invaluable. They sometimes can be involved from the very beginning throughout the entire process. They can gather the financial information, help with the gathering of the financial documents such as the pension information, retirement accounts, real estate documentation, and valuations of businesses. If there's a business involved, that can be quite complex. And they're not financial planners. They will not help give financial advice to the parties, but what they will do is digest the documentation, the information and the data, and present it to the parties in a way that hopefully makes sense, and then give them options and say, okay, we discussed this possibility, we discussed this possibility here, option B and option C. Here are what they all mean. Here are the budgets for each situation. It's a hands-on approach to helping and informing a couple who is divorcing to see what their married life is and then see what their life will look like after the divorce takes place. And oftentimes that is a total shock to people. And having a financial professional involved in the process helps address what otherwise could be a very mysterious and scary outlook for each of them. Okay, sorry. There are other professionals involved, tax accountants, business or estate lawyers, real estate professionals, and so on. Oftentimes these folks are brought in for isolated issues. I recently had a mortgage broker come in just for one issue on a case, just to see what the specific circumstances or the outlook would be for one spouse to potentially get a mortgage while staying on a mortgage on the marital home, and what they would need and that type of thing. So not all of these individuals need to be trained if they're not involved throughout the process as far as collaborative practice, but it always helps. You'd be surprised how many people are trained in collaborative and want to help in the collaborative process. And there are resources, and I think we have a page at the end of this presentation with resources where you can go and find people who are trained in collaborative, also mediators as well, to be brought in. And these people are available for mediations too. It's not uncommon for a mediation to be taking place and have a complex tax issue or a complex a business valuation, and just bring someone in trained in these areas to help. But I find them to be very effective, and a lot of them are very interested and care a lot about people going through a divorce, and try to demystify any of these issues and solve them for them. So yeah, it is not mediation. It's very similar. As I said before, as a mediator, I'm very passive. I'm more of a facilitator helping the discussion, but the collaborative process is a team concept. You'll hear a lot of discussion about the team. The team is going to meet. We'll have team meetings. It's a partnership. We're all looking for the same thing. We're all trying to get that agreement that is the best customized resolution for this family. And we brainstorm ideas. We throw ideas back and forth. We help. It's more of a hands-on approach. It's a team approach. The parties do not feel alone. And we recently had a signing of an agreement, and everybody was giving hugs at the end. And we never thought that would happen, because it was very contentious in the beginning, and we're all shaking hands and giving each other hugs at the end. And it was a true team effort. And it was a great thing to see happen. You don't see that in litigation. It just doesn't happen. But by the time the litigation is over, when the case is over, people are just like, let's just get this done. But not so much with mediation, or especially collaborative.
Great, thank you.
Yep.
So it's just a quick overview. It's basically all of what we just talked about. We just went over collaborative. It's a team approach. It's open communication. Professionals committed to the process, committed to keeping the process out of court. Mediation it's also confidential, but it's with one impartial mediator who guides the negotiations. And then litigation is the court involvement. And you can enforce orders, you can get formal discovery, although there's less control of the outcome. So here's just a quick overview of like how the time frame compares. A lot of people want something quicker. Mediation typically takes 1 to 3 months. Again, that depends on how devoted the participants are. Collaborative can take 3 to 6 months. That might depend not only on the commitment of the parties, but also the availability of the team. A lot of times collaborative has some outside issues, whether we need to get an appraisal done, business evaluation done. So that might slow down the process as compared to mediation. But really, for the most part, everyone in a collaborative process is devoted to moving the process along. So any delays is just what's necessary to move that process along. Litigation is a much more extensive process. You're subject to the court's availability. There are some timelines, like if you're doing a contested divorce, you have to wait 6 months from the filing, from the service to the date of the agreement is entered. But it can often take a lot longer. Even when you end up with a settlement, it can take anywhere from 12 to 24 months. Or even longer if we're going to trial and waiting for judgments. So Rick, here's a couple of real life scenarios of what might work best in certain situations. If you want to walk through these, please.
Oh, sure. Do you want to do the litigation one?
Sure. I talked about that a little bit. Couples with high conflict, distrust, litigation can provide structure, can limit the destructive behavior to some extent. On the con side of that, people can use litigation to add to this destructive behavior, but it does allow court orders to be put in place to limit certain people's behavior, limit the parenting time, and really just put rules and structure in place for the way that the divorce is going to occur. The other one would be couples with complex assets, needing appraisals, discovery, and again, you need that formal discovery. I talked about that before. Needing some mechanism to ensure that the information that the parties need is obtained. Go ahead.
Yeah, and so mediation, for example, a couple with some disagreements, they can agree on most things, but they have some isolated issues, and they obviously don't want to go to court. So they might bring somebody in, such as myself, or like I said before, if it's a specific issue as to finances, maybe they'll seek a mediator with a focus on financial planning or some financial professional. Or if they have children with special needs or they have special circumstances involving their kids, there are children therapists who are mediators, who can help with that aspect of it. Or also someone, with conflicting schedules and scheduling and things like that. So, and also, again, you can get a therapist or someone who's trained in collaborative or mediation to help with that part of it as well. So there's a lot of flexibility for mediation for people who are almost across the finish line, but I don't want to sell mediation as something that's only for someone or parties that agree. Really, for mediation, the only agreement you need to make is to mediate. So there does have to be some trust there, or mutual trust. And with collaborative divorce, there's a cooperative process. We don't want to go to court. I don't entirely trust him or her, or there's a power imbalance, but we just don't want to go to court. And so sometimes I'll say, okay, well then collaborative might be best for you, because you have the structure of what might be considered litigation, but again, the freedom and the customization that's not available through litigation so much.
So we're going to open it up. If there's any questions, comments, anything that anybody wants to raise, we'd be happy to answer any questions that you may have. Different points of just go ahead and unmute yourself. Yes.
I am muted. Thank you for doing this. First of all, I love that you're doing this. I, don't know why family law practitioners don't bring this stuff into light and keep it in the shadows. And I'm so glad you did. It was very thorough. But I want to ask you a couple of things on the collaborative divorce. What kind of training do you have to go through to be able to hold yourself out as a collaborative divorce attorney?
It's training through the Massachusetts Collaborative Law Council. I believe it's 2 days by Zoom, and they're only offered once a year, at least right now. They used to be, I think they tried it twice a year, 1 year, but there's really not. I'm on the International Academy of Collaborative Professionals membership committee, and my job this year is to try to recruit as many lawyers as possible, because part of the reason why people don't know about it is because there just aren't a lot of practitioners who do it because they don't want to bother with the training. They're comfortable with the practice. They just don't want to go through more training. And so they don't really see the value in it. And it's really too bad, because it's really not only better for, I think, for the general public, but I think it's, as a practitioner, I'm telling you, having been through all three forms of this, mediation collaborative for me is far more rewarding, because the end result is far superior, I believe. But there's a link at the end of this for the Massachusetts Council of MCLC. I can't remember. I just can't remember the acronym.
We'll get to it.
Huh?
We'll get to it.
Yeah, we'll get to it. But I believe there's training in March this year, so it's coming up very soon.
I have a collaborative divorce follow-up question, if I can stick with it.
Mm-hmm.
So I'm assuming not all collaborative divorce procedures, for lack of a better word, are successful.
Right.
Have you, in your experience, found like any common reasons that might make them the collaborative process fall apart or not reach a settlement?
The only thing I can think of off the top of my head is that one of the parties doesn't want the divorce in the first place.
Really?
It
Actually,
takes
I'll
two.
answer that question because I litigated a case that fell apart
Oh,
post
go.
collaborative. And the reason was, one of the reasons I talked to was one of the parties was very controlling and manipulative, and my client needed that court structure because he just wouldn't reach an agreement. Rick talked about the agreement is to come here and reach an agreement. He wanted to come here and get her to reach his agreement, and that's that power imbalance that doesn't work in the collaborative or mediation process.
Cool. Thanks.
Yeah, thank you. Any other questions, comments? Go ahead, unmute.
Thanks for doing this. How often do you see things that start out in mediation kind of move to the next layers? Is that a common occurrence that people start the process that they feel like, oh, we can get along, and then it just kind of maybe devolves from there?
Yeah, I think it's the same idea. People a lot of times want to, like, hey, okay, we know we want to get divorced. I've had people say, oh, we've resolved everything, and then sit down for mediation. I usually see the aftermath. Rick would see the actual mediation piece of it, but I see the aftermath of them saying, we tried a mediation and he wouldn't agree to this. She wouldn't give me this document. We have all these very different philosophies. So they just, again, it's that power imbalance that they couldn't there was no meeting of the minds. So I wouldn't say it happens a lot, but it happens.
I've been thoroughly impressed by people who come into mediation, and I have my doubts as to whether or not they're going to make it through. And then they leave, fighting and screaming at each other. And then the next thing I know, they're ready to come back and they've made progress on their own. So I think people, once they make a decision to do it, as long as they're both sincere, except for that one exception that Teresa was talking about, I think for the most part, they really do want to see it through because they know the alternative is probably much worse than what they're going through at the moment. So,
Any other questions, comments? Anything? All right. So just a quick recap. I know we've gone over this a couple of times now, but I think what's really important to remember is that sometimes the approach, like we just talked about, needs to be changed during the process. People come in, and some people are really devoted to the mediation process or collaborative process, and it's fantastic. And those people who are devoted usually really end up with a great result, as great as it can be for their family. But sometimes it needs to be changed and interwoven. Sometimes a lot of times mediation and litigation are interwoven. But there are a lot of different ways that people can reach the result that they need to reach, that they can get the end of this process. And I think it really takes just understanding where the situation is for each person and helping them understand what the best avenue for them is. So as Rick mentioned before, here's that guidance that we had discussed. International Academy of Collaborative Professionals. It's the international version of collaborative. It's a great resource. There's a lot of information. You can search for professionals of all kinds of disciplines. There's also a local chapter, or a local version of it, I should say. Massachusetts Collaborative Law Council, again, another great resource. Massachusetts Council on Family Mediation. There's a lot of really fantastic mediators that are enrolled in that organization that you can search for professionals that would be a good fit for your situation. And the last one is the Association of Family and Conciliation Courts. This is more of a general organization, but it's a really powerful organization. They do a great job for family courts. They prepare guidelines on custody issues, custody evaluations. They're really the forefront of family law issues. There's a great presentations, great teaching for attorneys as well. And then there's our information. So anything you want to add, Rick, to finish this up?
no, that's it.
Okay. Well, great. Well, thank you everyone for attending. We really appreciate it. If you would like a copy of this, let me know. If you know anybody who would like a copy of this, we'd be happy to send it out. And thank you very much.
Thanks, everybody.
Thank you.
Excellent job.
Thank you.